Good morning and welcome to our Navigating the Path to POPIA Compliance webinar. POPIA is in effect, so now what? So thank you all for joining us today as we really delve deeper into the important issues that people are facing and the insights into the evolving compliance journey. We always welcome your active participation in our events, so please do use the Q&A functionality and pose any questions that you'd like answered. We will be discussing these during and after the panel discussion. If you'd like to voice your question or points directly, please utilize the raise hand function and I'll promote you to the panel so that you can ask our experts live. This is your session. Find out and ask the questions that you want to know. I'm now going to hand over to Daniel Robus, our host for today's session.
Thanks, Carrie. And I am doing an outside broadcast today. So my coffee is sponsored from Seattle, but the home brews, I had to make it myself, overlooking the Crocodile River in Kruger Park. It's amazing, but that doesn't excuse me from doing the work that I had to do. So I'm in. The Wi-Fi is really great. If you're involved in Wi-Fi and making it happen, thank you that I can work from anywhere during the school holidays. And I'm really quite excited for this session. It's close to our heart. You know, Carrie, you and I put events together like this, and POPIA has been quite scary as we've been thinking about where do we go and what do we do with these, with this act, and what are we allowed to do when calling customers. And I think it's in for the right reason. So I'm really excited that we've got a panel together today of folk who have dived into POPIA, boots and all. Secretly, I'm working quite closely with them as well. So I've got vested interest in their success. But I'm working with Tanya Langbein, who Tanya and I have worked together for about 17 years. She's always been the senior to me. So when they talk about glass ceilings in the workplace, Tanya sure has broken through that in a number of areas, and I'm going to be speaking to her from a C-level perspective. How's it, Tanya?
Hi, everyone.
Then we've got Rich Bradshaw, who is the youngster on the group. He's just been having a tough quarter. Richard comes from a farming background, has been implementing Oracle or ERP solutions for a long, long time, then into the integration side, diving into the technology, and is now spearheading the POPIA readiness assessments and where the applications are taken from a WCH perspective. And the new kid on the block. Good morning, Rich. Do you want to say hi to everybody?
Morning, all. Thanks for attending.
And then we've got Alex, who is first job, I think this is, hey, Alex, getting into POPIA and sorting people out from a POPIA perspective. Good morning, Alex.
Good morning, everybody.
Now, we know that POPI is launched, POPIA is launched. We know that it's now live and the government could be enforcing this legislation. But there seems to be a lot of confusion that's going around. And today's session is really to clarify questions that people have had. And Rich, I know that you know, you've been speaking to people from home associations through to schools, through to medical practices and everything in between, because personal protection covers and affects everybody. And I had a really random thought this morning. We're not allowed to geolocate when you see a picture of a rhino. Is that because of POPIA, or is that because of conservation nature? Does that touch POPIA in any way?
No, don't. Thanks for the question, but not at all. POPIA talks to human people and
okay.
Yeah.
As opposed to rhino people. Okay, cool. So we've got stratospheres of customers. We've got these enterprise customers that are working with POPIA, and we've got what most of us are small to medium or small businesses. And we're going to try and touch on all three of these areas today. But Tanya, a question for you from a C-level perspective. Are you seeing that privacy teams are getting board level buy-in for this POPIA program and the privacy program? Are you seeing traction coming through that people are taking this seriously?
So I think it all depends on where the original thinking is coming from. So if a privacy team inside an organization is trying to promote and embrace POPI, without the backing of their board, they will really, really struggle. If it is coming from the board and the board are saying, we do understand our responsibilities to this POPI Act, and they empower the privacy team, then they are guaranteed to a road of success. It all depends where the original thinking starts. It must be at board level. It is a board responsibility, and it must be driven into the organization thereafter.
Okay, so we can't delegate it away. Did you want to add to that, Rich?
Not really, Dan. I think that was the intention of the regulator and even the Act. It puts it at board level.
Okay, so we're going to be, yeah, carry on.
Add some more to this. I think in many cases, I see it as a to-do item, an item on someone's to-do list in the organization at the wrong levels. It must be an item on the board agenda and then looked at whenever the board meets, and obviously on someone's to-do list as well. If it's just on a to-do list and delegated away, it will not be backing it. It has to be on the board agenda.
We've got two questions that are coming through, and I really like Tolu Akarele's question, which is, under POPIA, do you need explicit consent to call customers to respond to open customer services cases rather than by mail? And Alex, I'd love you to dive into that one, or Rich. So as I understand this scenario, we've got the customer, they are our customer, and we're servicing them. Can I phone them?
So to answer your question, then you can phone them and send them emails and so on when they are an existing client or you've previously sold similar products or services to them. But you do need to give them an easy way to opt out with every communication that you send to them. However, if it's a new client, if that client is not already on your if it's not a client and you haven't sold similar products or services to them in the past, to communicate to them via direct marketing, emails, SMSs, and so forth, you then have one opportunity to obtain consent from them.
Okay, so let's go back to Tula's question. This is a customer who we have, and we've got a customer services case. We can phone them for them. That's not the intention of this legislation, is to cut you off from doing your business. Okay, so we answered it. Thanks, Tula. I can see Zan's responding to you. Gary's then got a longer question, which I'm going to ask. The company that he works for runs online events on a daily basis that people register for on their website. We've created a CRM journey, and I'd like to understand if we're allowed to add these customers onto the email journey using the details they've provided in their registrations, or do we have to actually also do an opt-in mail drive even after they've registered for an event? Rich, I wonder if you could dive into that one.
Similar to Alex's answer, in this case, if it's a new customer, they need to, it would be assumed that if they're registering, they are interested in the event, and it can be taken that that is their consent.
Okay.
So it is in fact by default consented to that you contact them in that particular instance. So I think that answers the question.
Okay, so from both of these, what I'm seeing is that the Act isn't there to prohibit you from doing the work that you've been doing. It's actually to look after the information and use it for what it's meant to be used for. So Alex, I'm going to go down to you. I'm going to skip Rich here. What are you actually doing for WCH with regards to POPIA?
So then we've got our POPIA starter kit tool, and what I do is I give the feedback based on that tool, and I get into some discussion with the client about what they are doing, what their scenario is, because it does differ from person to person, and that's why you can't completely automate it. But it's at that point where we then get into some detail into their business.
So you've gone and your job was to look at the Act and then interpret it as the customers answered questions in order to make sure that through bouncing with one another, we make sure that we've got compliance. That's predominantly your focus. And Rich,
Yes.
do you see this, and this is an opinion piece, this is for you, your opinion, do you see this legislation as protecting customers but inhibiting work, or if embraced, do you see that there's any benefits to people for this?
And great question. The spirit of the law is not to inhibit or constrain. The spirit of the law is to protect. So if somebody is acting irresponsibly, one would probably not do business with them. But if they have complied, the benefit would be that I am quite happy knowing that that organization or that individual is aware and is intent on complying with the spirit of the law, that my information is protected, and therefore I'm more likely to do business. So the benefit is, if you comply, you're likely to get more business. If you're not compliant or show intent to be devious, the likelihood is you'd lose business.
Okay. So this is almost a foundational layer that's been added for us to do good business, to be a good corporate citizen. And in order to do that, there are a couple of gates we have to go through to maintain POPI compliance. Now, there are a couple of questions coming through. Carrie, you know me and Anonymous. I don't like, put your hand up. We want to see how gorgeous you are first thing in the morning. Let me know who you are, damn it. But David's asked a question, which is quite a long one, and I think this fits into your gambit. How do I ensure the federation where I'm the presiding officer becomes compliant in terms of the POPI Act? And what channels do I have to follow to get certified as for being compliant? Do you want to chat us through that, Rich, and just tell us where we are on that from a broad perspective, Dave, and then David can get his answer?
Okay, thanks, Dan. I might ask Alex to chip in as well when I get stuck or need to get more specific about the Act. But the appointment of an information officer is quite key. Small business typically wouldn't have an information officer, and therefore the law by default makes the CEO or the owner the information officer, the responsible person. So as the CEO or owner, you are the responsible person. You can delegate that responsibility to an information officer. If you're an organization that can carry the cost of an additional person. The information officer is a C-level appointment, back to Tanya's question earlier, and therefore it is a board level role. In terms of federation, there are specific guidelines put out by the regulator, the information regulator, as to what is expected of an information officer. Whether you're the default CEO or an appointed information officer, there are guidelines. It is on the website. It is available all over. We can send you the link as well. But at the end of the day, there are guidelines as to what is expected of the information officer. And it's basically to move towards compliance. If there's any interaction with the regulator, or if there is any complaint by a third party or data subject about information that may have been leaked from your organization, the information officer must account for that. He is terminally accountable for the data protection and the promotion of access to information.
Awesome. Tanya, carry on.
I think David's question ends with, how do you get certified as being compliant? I think it is important just to note that you never get a certificate of approval. The POPI Act and looking after data is an ongoing journey of compliance. Employees leave, come, customers go, customers arrive. It is not a do an exercise, get a certificate and you're done. There's also annual impact assessments that have to be managed. So you never get to the point of being certified, tick, exercise complete. It is a living responsibility, a living fiduciary duty of the board.
Okay, so if we're exercising regular updates to it, if we're managing the data, if we're purging the data, we're showing intent. I think that's why you talk around that starter kit, where it doesn't get you to certification, but it gets you on the POPI road. Okay, now I understand that. I've been prompted to go to Anonymous back because there's some excellent questions there. Whoever you are, you Anonymous, you loving person. Let me see. If a customer asks that they would like their information to be removed, does this include records in a project-specific database for prior projects? In this case, we would remove contact details, files, and any other company data. What about backups? What a great question. Okay, I will read the Anonymous from now on. Who's taking that? Alex, are you taking that, or am I Brad showing that?
I'm taking that. So the data subject does have the right to ask you to delete his information. However, you do have other obligations by other laws. So POPI would be subject to any law that is broader or has broader guidelines on something. So in terms of if they ask you to do that, it would depend on the other applicable laws. So let's say you are required to keep that information by law, by another law, you would then keep that information. But you would stop processing that information when they request for you to do so, yes.
So if we have to keep invoice data, I mean, that's not in project. If we have to keep invoice data for 10 years because the Act says so, that supersedes what POPI is saying here. We don't have to terminate that transactional data. So we don't have to be, we always have to be cognizant of the laws that are overriding. Okay, that's pretty good. Charles, I can see you want to ask a question. I'm going to ask Carrie to pop you in, and then I'm going to get to Feroz, Petra, and Anonymous again. Okay, Charles, go.
Yes. Thank you.
But you got to put your camera on if you can. Otherwise, you can't ask a question.
Yeah, my camera is on.
Oh, I can't see you. Okay, go, Charles.
Yes, what I wanted to ask is, oh, sorry, it was muted. What I wanted to ask is, but the POPI, I think the POPI was a law-driven legislation, which was not well thought, but it should have been a technical legislation because it should be integrating with other laws. For example, I can give you a classical example that it's a nightmare over everyone. It's silent on how the data subject information should be secured. The reason why I'm saying that, people are being scammed. The banks, the custodians who hold the data, the banks, your money, the accounts are being opened in your name. They are used to transfer the money, but there's no consent that comes from the bank to say that the bank alerts you that there's a transaction that is going on through your, it's used to scam people. And the data quality within the bank, it's never ever been challenged. So that's why I'm saying, like, this legislation was drafted from a law perspective, but it should have been a technical, such that it pulled all the legislations together. For example, it should have pulled National Credit Act to say that when there's this high amount of money that travels your account, do you afford that? Is it a legitimate process? Does the bank give authorization for someone? I mean, most of the ATM have access to their footages, and they know they captured our images. Do they authenticate to ensure that whoever withdraw the money through your detail, is it the right person? Because of, they say, keep the information to the subject, to the process that is being identified for. Is it the identified process?
But Charles, are you asking a question or are you making a comment on POPI? Because we agree with you. I mean, I think that the reason why we all got together on this webinar is that people just want information and clarification. So it's here. But we've got to deal with it now and make sure we're good corporate citizens. So what are you doing about it? What are you going to do about it?
No, for me, I'm actually one of the people who will like the legislation to have also a second round of review, but already all the companies, we are implementing it. We are aligning to it. There's technical requirements that are being implemented, but obviously they can supersede some of the things. So we have to respect that. That's why we say that the punitive measures to the data hold custodian, it's a bit silent and it's blur on some of the clauses, and also even from the data subject, there's silence because of like even the update of the data. It doesn't give the custodian to say like, how should you notify the people, the data owners, to come and update their data. So those are the things that I see as technical challenges.
Okay, cool. Thanks, Charles. Tanya, Charles brought up a really good point there when he's talking about business-related activities and putting in new ATMs and spreading in the banks. Do you think, what are the privacy challenges that are created by this business, by business expansion-related activity? You know, when we are going now and we want to extend our organization around the country or even offshore?
Sure, Dan. You know, I think that's why, big question, by the way, but that's exactly why this legislation or this law is a living law. Companies will expand, companies will, you know, dissolve areas of their business and close areas of their business. And because business is not static, this law is something that you have to practice. And, you know, the responsibility is first, the information officer. Second is to create awareness. Third is to continuously review policies and procedures. And as your business grows, shrinks, changes, transforms is the big word here right now, digitizes, these things have to change. Awareness continuously be top of mind, and policies and procedures need to change as businesses morph. And it's continuous. And in this day and age, when everything has become agile and everything is fast and furious, it means that things that are normally like reviewed maybe once every 5 years need to be reviewed on an ongoing basis by the information officer and the people who report to them, like privacy champions, etc. And with them inside the various departments, bless you, with them inside the various departments, as things move and change, the organization should continuously be aware and change with times. And times are changing fast nowadays. I'm not sure if that answers your question.
Yeah, 100%. So that probably is a segue into you, Alex. How do companies, so if I'm the information officer and I've delegated it down to someone else that's in a processing area, how do we keep up to date with the changes that are coming through POPI and through the regulation? But the contrary is, how do we make sure that we're aligning to the regulation from a process perspective?
All right, Dan, so good question. So the regulator is, one of his responsibilities is to have a strategy of making everybody aware and, you know, just passing on the message so that everybody is informed. So the regulator does have some guidelines on various different things, and there's quite a lot of information that he's already made available for people to go and read. Another good one would be to watch webinars, because you then get to see it from a bunch of different perspectives. And as for keeping the policies and procedures up to date, you would, because you're the information officer, you have the responsibility, and you have the responsibility to know what the Act is requiring from you. And so what I would suggest is just, as Tan said, just keep on informing yourself, and then keep on reviewing your process. You know, do you need this information? Are you collecting too much information? And as it goes through the process, is it being used for the purpose for which you've notified the data subject? You know, is it being protected? Are there safeguards? Do the right people have access? There's a bunch of things that you would look at, but you would follow the information throughout the process and go and look at, is this information safe?
Okay, awesome. Thank you. That's good. There's so many questions coming through. I'm going to go off piste and follow them. Jaco Liebenberg has asked, what are the responsibilities of schools, teachers in terms of children and PI? Jaco, we are actually hosting a couple of these webinars, and one is specifically for educators, and I'll ask Alex to get in touch with you. So Alex, if you could just take a note to get hold of Jaco so that we can have one on that, because it's quite in detail. So I hope that answers you. Then Feroz has answered an easy one for Richard Bradshaw. Do we need an info officer for a residential complex? Because his previous question, which is an essay on its own, it's a thesis, Feroz, is Richard, your second part of your question is homeowners association is represented by a management agent. The management agent blind copies all on the email in order to protect individual privacy. Is that not taking it too far? Was this a requirement, seeing that the email correspondence is to all homeowners or a specific group of individuals? So take both of those, please, Rich.
So to answer your question, Dan, each entity, including homeowners association and governing bodies and various other types of boards that run residential or corporate business estates, are required to register with the regulator. It is a thing that they have to do. And part and parcel of that registration is the nomination of the accountable person, whether it's the CEO or the owner or a trustee or a chairman or whomever. The regulator wants to know who is the responsible person as part of the registration. So the answer to the question, does the residential estate board trustee need to appoint an information officer? The answer is no, but somebody needs to be nominated. So it doesn't need to have the label information officer, but somebody needs to be held accountable, that the regulator can approach that person about any challenges or compliance.
So Feroz, there has to be someone on the chopping block.
Yep.
Okay, Feroz, that's you. Okay, moving on. Second one answered.
Second question is, sorry, Dan, what was it again?
So they've outsourced a lot of their work into a management agent, and now the management agent is BCCing everybody on any correspondence. Is that required?
Good question. There are a few things at play here. So firstly, the responsibility for the accountable person, whether it's the CEO, trustee, appointed or nominated information officer, cannot be outsourced. It has to be with a person who is within the organization's authority. Now, the Act describes and defines that quite clearly, but it is specifically, it cannot be outsourced. So the role of accountability for privacy and protection cannot be given to a managing agent. Clear answer, it's in the law. Second part of that is that if a residential estate has appointed a managing agent, there needs to be a contract. It's a third-party contract defined by the law, by the POPI Act. A contract has to be in place defining the limitations, the constraints under which the third party can operate on behalf of them. So if the managing agent is sending emails irresponsibly,
yeah,
and without due consideration, firstly, they need to be brought to book, But secondly, is there a contract, third-party contract in place that defines all of this, that they can work within and what they can't do? So that's a very important component when appointing any third party, not just a managing agent. If you have somebody looking after your security and they have access to personal information, being the person's name who's in that unit in the complex, these are all operators or third parties that would service a residential or business estate. Third party contract would cover those things.
Alex? Just to add on what Rich said there, so you would also need to notify the data subject of the fact that their information is going to be shared with a third party. So that's also part of, you know, just promoting the openness of this, so that that data subject is aware of the fact that his or her information is going to be shared, and, you know, the possible consequences of that.
Yeah. Okay. There's a lot of misinformation going out at the moment. And I can see Zan is answering a question there, but I just want to raise Albert's question to this panel. And it could be for you, Tanya, or maybe for Rich, but he's a consultant and in many cases needs organograms and details for the people who fills positions. So I'm assuming he's a strategist or a strategic consultant of some sort. So far, everybody seems too scared to give me the information. So he, in order to do his job, he needs information. He needs information of the employees, but people don't want to share it. Are you seeing a lot of that, Tanya? Are you seeing people that are scaremongering to share information under the POPI Act now?
I think before the POPI Act, people were always reluctant to share what was considered personal information. Now there's just an act that comes with huge fines, which probably scares people even more. For me, the key to unblocking this fear is to make sure that the people you're engaging with, I'm not sure, who's this person who asked the question?
Albert.
The key for me is to make sure that you continuously communicate the purpose as to why you are asking for this information. And if you are clear on the purpose, and the purpose is relevant and of significance to the individual you're targeting or wanting to speak to, they should, you know, become more comfortable with sharing it. Now, if the purpose is well understood and the person you're engaging with appreciates the purpose, then they should be more comfortable in giving information. Purpose is the key to everything when it comes to collecting information in this new age.
And sorry, can I just have a few minutes? It also shows me that there's an element of unawareness. The person who is being requested for the information, the person who's reluctant to give the information, is doing it because they are either misinformed or not fully informed as to what questions they should be asking or what information they can and cannot be sharing. So there's an awareness component to this as well.
That's brilliant, Rich, because we have been jumping around a bit, and the feeling that I'm getting is that all of our friends attendees here need to establish a foundation, a compliant foundation, which says we understand our business and our processes. How do you give that to people, Rich? What do people do in order to argue these things from a firm footing? What are the first, second, and third steps that we go through?
Yeah, Dan, great question. And you're right, there's quite a lot of misunderstanding here, and it's actually quite easy to follow. You opened the session by saying that there's various levels, and there are the C level, who are responsible for policy and guidelines. Then there's the executive level or the operations level that needs to implement those policies and guidelines. And then there's the operators who work with it on a day-to-day basis. And all three of them have a different responsibility and obligation. And honestly, there are lots of awareness. There is lots of awareness content on the web. There is some better than others, but basically, you need to get somebody to structure. It is part of the information officer's responsibility to create awareness within the organization. So there should be a mandate from the information officer that there are seminars, there is TV broadcast, there's some level of awareness training at all the various levels in the organization. And it's a very important component of compliance. If somebody doesn't know that they are processing a piece of personal information, how can they be compliant? It is very important, the awareness training.
Okay. And then, so where do we go to? How do we take a customer from here, from where we are all confused, onto a point where they can say, okay, we've done the right thing, and now we can deal with these customer things, Tanya?
You're asking me? That's an interesting one.
It is. It is.
Of Richard and Alex, but
No problems.
the thing is to start the journey. So we have the starter pack, which they have mention of, and then we have expansion packs as well. So really, at the moment, we've got like a 3-step process to get you going. The minimum being starter pack, and then 2 levels of expansion thereafter. And as I keep saying, it's a journey, so it will never end. But we have 3 that will help get you going in the right direction. I don't know, Alex or Rich, would you like to expand?
Yeah, so what we do in this starter kit is we start off by getting you, getting an information officer appointed. You know, we deal with the first steps. You know, we do your assessment. We use a questionnaire for that, and we then get our automated personal information impact assessment. And based on that, and based on how you answered the questions that you were asked, we then have a discussion, and we get down to the detail, and we get down to what are the problems, what are the biggest problems, what are the low-hanging fruits that you can go and fix immediately. And that's where the expansions would come in. If you don't know how to do that, we can then step in and help you with that after you are now aware of what the problems are. So
the step 1, 2, and 3. Step 1, register. Step 2, identify your processes. Step 3, see where there are problems, and then start sorting them out. Okay, cool. We've got Themba Mnguni, who is wanting to make a comment. Your hand's been up for so long, you must be tired. How are you, Themba?
A good day, everyone. Thanks, Daniel.
Thanks for joining us.
Yeah, thanks, man. I'm a little bit worried here. After listening to what has been discussed here since the start of this event up until now, one of the things that I wanted to sort of be clarified on was how, okay, let me give a little bit a background of myself. We are information systems auditors in my department. Our role, one of the things that we need to do is to conduct an audit on POPI. And our Director General, there's something that he wants to achieve. He wants this department to be POPIA compliant. And he relies on us as information systems auditors to go through these processes that have been implemented by the department and be able to report to say whether this department is now compliant or this department is not compliant. Mm-hmm. I was maybe expecting that maybe that maybe we could be able to be clarified in terms of saying how do we, because the way I'm looking at it, it sounds as if we will never, in fact, all the organizations will never achieve what I would call a compliance status. I'm not sure if I heard your panelist clearly. So it is a little bit worrying for us because it could mean maybe POPIA, there's some weaknesses there, or maybe the information regulator might need, to, I don't know, update certain things. Because
I would love before you go, Themba, I would love an answer on that. Rich or Alex, do you want to comment? Alex, go for it.
Yes. So Themba, there's no certificate saying that you are compliant at the moment, and you know, we are anticipating that maybe later there might be something like that, but that's just there's no facts on that yet. But I do think that businesses can become compliant, but I also think that they would still have some risk that they need to manage in terms of the personal information. So every process can be looked at, and all the errors, all the you know, things that are wrong in terms of processing personal information can be taken out, but there will always still be a risk of breach. There will always still be a risk of these things.
Okay, so just pause there, Alex. So there isn't a compliance certificate, but there is compliant behavior. So you're saying is that we're never going to reach an end goal, but we can prove intent, because there's a lot of questions regarding security breaches that are coming through here. And what you're saying is, if we've put in the compliant behavior, then the regulator is less likely to slap you when you've had a breach of some sort because you've been trying.
So
is that what you're saying?
I just want to quote from the Act here so that it's factual. So what the Act says is that the responsible party needs to ensure that reasonably practicable steps are taken to ensure that the information in their possession is secured. So obviously, we know that it's very, very difficult to be 100% completely safe from being breached. And that's why I think that those words were used: reasonably practicable. What is possible for you as an organization? And as long as you can say, listen, Mr. Regulator, these are all the things that I implemented to make sure that I protect this personal information, and yet I was still breached. That situation will then be assessed by the regulator. And I think that if you can show that you tried your absolute best, and these are all the things that you did, you would be more likely to get off a bit easier, if I can use those words. Yeah.
Okay, cool. We've got lots of questions coming through. Folks, I know you've got very many questions regarding data and where it's gathered, regarding WhatsApp groups. We're going to try and get through to all of those. I've got Adai, who's going to be the last person coming in to have a chat. He's been waiting for, or Adai's been waiting for ages. So Adai, if I can ask you to keep your questions succinct.
Can I quickly just add to Timber's question? Sorry,
sure.
To interrupt. It's very rude. Timber, I think your senior leadership are asking you the right thing. They were asking you to show and prove that the department is compliant. They didn't ask to show that the department is certified. So that is a good thing, if I take your words. They were asking for compliance. Now, we do have tools that show you your level of compliance, and they can be two types: the opinions of the people within that department, and also we can run from a technology perspective, so give you a system view, a data system view of your level of compliance. And I just wanted to say to you, it is very achievable to give you a department view of their level of compliance using human interaction as well as in system interrogation. So your leadership are doing the right thing by asking for level of compliance, not a certificate. And we have the tools to prove that for you, and you can document that and then update that annually along with your impact assessment report. Daniel, sorry.
Awesome. Okay, Adai.
Thank you for the opportunity. Good morning, everyone. So please, still on the compliance. If you are conducting a research and you need to ensure that your methods are POPIA compliant, how do you handle that? Thank you.
Wow, great question. Go, Alex.
So sorry, I didn't, it broke up a bit there. You need to ensure that what is compliant?
Or Richard?
Your methods, your methodology.
Yes, your methods.
If you are handling your research and you need to. So thank you.
Yeah. So what you would go and look at is, so from the point of capture, right through to when you destroy that personal information, are those measures effective in ensuring that that information is processed correctly in terms of the purpose, and is it secure? And do you notify the data subject of all the things stipulated in the Act, as in Section 18 of the Act is what speaks specifically to that, is notification to the data subject when collecting information. And then are the data subjects throughout this process enabled to practice their rights with regards to the personal information? So you would go and look at how effective the measures are in accomplishing those things. But that's
awesome. Guys, we've got lots of really interesting questions, so I'm going to run through a few of them. Albert Visser has asked, what do you do if people are using your information without permission? Take them to the regulator, I think. And I'll let someone answer that properly, Albert, but let me get through a couple who have asked a few questions. Rich, I think this is for you. This anonymous person registered their marriage with Home Affairs in 2007 and Googled themselves and found ID number, names, marital status under the linked government gazette, but have been trying to remove it since. How do you deal with this matter?
Oh, interesting question, and probably, well, definitely not yet tested in law. But if the information is correct, then the Home Affairs Department have the right to hold the information and legitimately they're publicizing it, legitimately publicize it. So there are, I think, 6 or 8 lawful reasons for collection and holding of information, and Home Affairs have pretty much carte blanche with regard to holding our information. There is very strong consideration that they're under for how they use the information, but at the end of the day, they have legitimate right to the information.
Okay. All right. And then we've got Teddy asking about public clouds and data security outside of South African borders. And we answer that very quickly. Alex, go.
Okay. So yes, there are some problems with regards to that, because POPI stipulates that any business processing the information in South Africa, should comply with POPI, and when it goes over, it no longer falls under the jurisdiction. So if I remember correctly, I think there is some conversation or a form to be filled in for the regulator in asking for these kind of things around sharing the data with other countries.
I think the reverse is also true, where a foreign country or company uses a local data center. That data is subject to POPI. Even though the company itself is not resident in South Africa, the data is, and therefore subject to POPI.
Yeah. Okay. Then Richard, Colin has asked a question regarding security information, monitoring people for CCTV footage. Is there a difference between surveillance in a public space versus a private space?
Data subjects have the right to know when their information is being used or captured and for what purpose. And video and voice, as well as written and digital, physical, they're all subject to compliance with POPI. So whether it's surveillance cameras or, whatever, they are subject to POPI. You can identify the person, and therefore it's subject to POPI.
Okay, so we've got to let people know what we're storing their data for, and that they are being, okay, so if we've told them that this is under surveillance and it's for your own protection, people, we're looking after you, then that's okay.
Then it's very easy, sorted out.
Rich, you're breaking up quite a bit there. Tanya, is he breaking up on your side as well? Was it just me?
No, me as well.
Okay. Yes, you can. Anonymous has asked Carrie, it's actually a question for you. Will you be having a webinar about POPIA and how it affects marketing and sales for business? She put new business, but I'm just going to say for business. Carrie, do you want to answer that question?
I think after this webinar, I think we have to have POPIA webinars every single week to answer all these questions. But I think that is such a valid question, especially, you know, part of how Dan and I run the events, you know, and how we market it. So I find these type of webinars really, really pertinent for me as well. So definitely in the pipeline. Thank you for the suggestion, and I'll let you know when we're going to run it.
Thank you. Then Ushaila Naika has asked, what is data governance? Tanya or Alex, do you want to dive in on that? Alex?
Yeah, so it would refer to the framework in which data is governed by all laws that would apply to it. So POPI would be one that would apply to governing data and how it's used and so on, but there would also be other laws that would govern, you know, how it should be collected, how it needs to be, you know, retained and so forth. So governance is referring to the broader picture, including all the applicable laws.
Okay, awesome. Sylvia, you've got your hand up there. Do you want to have a quick question?
Yes. Hi, everyone.
Good morning.
Hi.
Sylvia.
Good, thanks. Yeah, my question, because I've recently started as a data protection officer, or in South Africa, an information officer for a non-profit organization that's based in the Netherlands. And they do a lot of work with a lot of personal information and various different projects in Africa and now South Africa as well. So my question, after having read the POPI Act, is my understanding correct that one would have to lodge the purpose and the means and also register your information officer before they can even start their duties? Okay, because that's my understanding, and they need to be registered by the organization as an independent.
That's a very good question. And so no, you don't have to register your information officer before doing any of these things. And especially considering that the portal to register is down at the moment. So there's also a grace period there's no deadline at the moment for people to register because of this portal being down. So the portal is being fixed, but there's no notice as to when it will be fixed, when people will be able to register again, or when they will be able to register. So the answer is no, you can do all these things. You just still need to comply with the rest of the Act in how you use this information and so forth.
Tanya, you wanted to add to Sylvia's question or to Alex's answer?
Sylvia, and Rich might correct me here if I'm wrong, but I do believe that at least you should know that there is a board resolution to appoint an information officer. I think that is the thing that you can do inside your own organization, or should be done inside your own organization while the portal is brought back to life. Rich, I am correct there. There needs to be a board resolution to appoint an information officer. That is your minimum.
And there's two parts to it. There's a board resolution, but also an acceptance by the nominee of the appointment. So it's one thing saying I'm appointing this person, but that person must also accept the appointment. But also you are probably, and maybe that's the reason for your title, subject to GDPR. Now the DPO and the information officer, so DPO is a typical GDPR title, information officer is the equivalent POPI title. So as a DPO, you have pretty much the same responsibilities and obligations on you to act on behalf of both POPI and GDPR. The fact that your head office is Netherlands-based, they are subject to GDPR. If they hold South African information there, they will be subject to that, and vice versa, as discussed earlier. So you definitely have to understand the POPI Act and the responsibility you have, but you probably also have to understand some of the GDPR stuff so that you don't go and default on responsibilities that your colleagues have.
Richard, Tanya, and Alex, we've got 5 minutes to go, and there are loads of questions, and I'm sure lots more. To the folk who have asked questions, we haven't got to it. Carrie's got all the details. We are going to get to your questions. We will get back to you, unless you're anonymous, in which case I don't know who you are, and then you're on your own. But I want to ask, and I'm going to start with Alex, what is your advice to people now going forward, where POPIA is in place, where the Act is in place? Where do we go to from here? We've got 5 minutes, so it's a minute each.
Okay, so my advice would be inform yourself, read anything on POPI that you can that is from the regulator. So just look at the source as well, but inform yourself and then go and look at your business and identify the difference, spot the difference and fix it.
Okay. Tanya, to yourself, you've moved from big corporate implementing projects and managing big teams into an organization that's looking at compliance as for organization. This is quite a big change for you. What are you most excited about seeing coming out for the next quarter from WCH in what you guys are doing?
So I have been in business systems for my entire life, and cloud came started about 10 years ago, and that was kind of interesting. I like doing bleeding edge stuff, so I moved into cloud. And I think what's happened in the last 2 years is everyone's talking about data being the new gold. And if data is the new gold and this trend is real, then the most important thing is to protect your gold, protect your data. So for me, I'd like to sign up with as many clients as possible to start their POPI journey, and then to build a continuous relationship with them. If data is the new gold of the future, we would like to be there to help you protect it. And the Act is here to enable it. There's some guidelines now. We have tools and techniques that we can bring to the party to make it far easier and not a labor, manpower intensive journey, by bringing some technology in from our side to help you and your employees and your customers and suppliers feel more comfortable in this crazy new world we're living in.
Awesome. Awesome. Rich, are you finding yourself providing recommendations on corrective actions, or are you more pointing out exceptions to people's every day? And how do you put this in context of the organizational priorities going forward?
Yeah, great question. And it's what wakes me up in the morning and gets me excited about coming to work, is that there is so much out there. It's so new that we are presented with scenarios daily, which we often don't have the answers to, but we have a team of people who go and research the answers, and we get back to the person who asked the question and have built some more knowledge for ourselves in the process. So yes, we certainly provide recommendations. We provide answers in many cases, not just recommendations, and we're there to help.
Awesome.
There's lots, I know, the number of questions on this session are not untypical. They're exactly what we're experiencing out there.
Awesome. Thanks very much. So Rich, Rich, Tanya, Alex, thank you very much. I could see Zander's joined us. He's frantically answering some questions. Thanks very much for that, Zander. Where can we go, Tanya, to find out more about us getting going with POPIA and getting our organization's POPIA sorted, and how does that work?
Well, POPIA sorted is the website, of course, .co.za. And then we have the essence of the company that is taking POPI to market is WCH Solutions. You can see it in the background of Carrie's shot there, wchsolutions.co.za. There's some links there. You can even
Thanks very much.
Take a link to a quick assessment and dive into the quick assessment and see actually where you are right now. So I challenge you all to go to the WCH website.co.za, take the quick assessment and start your journey.
Awesome. Thank you very much. From my side, Daniel Robus, thank you for allowing me to host the session. It's been great to interact with everyone. And over to you, Carrie.
Thanks again, guys, for attending today. I really do hope that you found today's session insightful and that we've answered some of your questions. I know we didn't get to everyone. I feel like the session could have been at least 2 hours or longer. So I have taken them all down. So the team, Alex will come back to you and make sure that you get the answers to the questions that you've asked. We will be making this webinar on demand for future viewing. So if you want to share with your colleagues, I'll let you know when this is live. So I'm going to say cheers from me. Stay safe, guys. Thanks for joining us today, and we'll see you at the next one.
Thank you very much, everybody. Cheers.
Cheers.